First of all, it's unenforceable because there's no consideration, but circular. A gratuitous promise is back for a moment at Hamer versus Sidway. Basically, the court said this was not a gratuitous promise where the uncle said, I will give you money if you, all these things, stop smoking, drinking, and gambling. The uncle, this was a gratuitous promise. There's no consideration here. The nephew was simply benefit doing. What did the uncle get from it? The court said forbearing exercise of a legal right can be valid consideration. So the court said this is not a gratuitous promise, it is enforceable. Let's contrast this for a moment with Kirksey versus Kirksey, where what we see again is the brother-in-law offering the sister-in-law access to cultivate, and the court comes back, they're not without conflict between the judges, to say, in essence, this was simply a gratuitous promise. The sister-in-law's action of moving a significant distance we considered a bargain for exchange result in anything going to the brother. Therefore, he can simply stop performing at any time, right? It simply doesn't have to keep giving it. So Kirksey versus Kirksey, again, no bargain for exchange. So you'll note that one of the judges was arguing for enforcement anyway on the basis of reliance. Let's see. So there are multiple relevant statutory provisions should you be interested in looking at them now, later, or for the purposes of your future bar prep. 71, 81. You can also look at Restatement 24, which in essence says that a gift is not an offer unless it's given in exchange for a promise or performance. Okay. Another element, what else is not consideration? Past consideration is not consideration, though we can think of exceptions, right? So in general, past consideration is a promise to reward or give something, or an act someone has already. So, have not done anything in order to induce the promise. In other words, you are not offering anything new. So past consideration is not generally considered valid for consideration. Now let's remember, however, if, for instance, you save someone's life and then they voluntarily then we would either view that as promissory estoppel, meaning the court will say, in this instance, we're going to enforce the promise anyway, past consideration, or the court is simply making an exception and saying if it is basically, it's analogous to having to pay an ER physician for saving, didn't agree in advance. So if you voluntarily say, yes, I'm going to promise you something in exchange for having saved my life, right, that's an enforceable promise, even though technically the consideration is past. Consideration also be valid if it is basically a more explicit promise to provide have already promised. Okay? So if it's just clarifying what you've already promised in exchange for something, it may also be enforceable. In general, though, aside from those exceptions, past consideration is not valid. Some states may have specific exceptions, so we're only going off of the general common law, in this case, that's likely to be true across states unless there is an explicit exception. Okay, other elements, as mentioned, we won't cover for formation other than definiteness. So the general doctrine on definiteness is if an agreement is not relatively definite, too indefinite, it's not enforceable. It's very vague, enforceable. The UCC has some explicit terminology fill in missing terms. So if it's a UCC, it may help to make a contract more definite. If it's not a UCC case, obviously that's irrelevant. And if it's a UCC case and that doesn't fit the vagueness or the lack of clarity in the terms of the contract, then it is not enforceable. In some cases, the definiteness may be achieved by partial or by reliance. Let's think about Hoffman versus Red Owl, which basically indicated to us that even if the terms are very indefinite and there wasn't even an offer, promissory estoppel could essentially kick in and correct the deficit of lack of definiteness. So all that we know about definiteness is that its absent means generally a contract has not been formed. As with any element, potentially promissory estoppel can substitute. So let's move next to the subject of promissory. So again, I'll acknowledge the new material you're starting to look at in statute of frauds also can be, in relevant cases, an element of contract formation. Most of that you know yet in the term one. So I would encourage you to review at least the basic material in cases we've covered thus far. My voice is cutting in and out. Okay, can folks hear me voice is off? Can you hear me pretty clearly now? I'm turning my mic way up. Worse. Better? Worse? Okay. Better. Okay. All right. Let me know if there's a problem again. So let's move on to promissory estoppel. So there are three elements always keep in mind relative to promissory estoppel. One question is, did the promise that was made reasonably induce something, action or a forbearance? Or the example would be Hamer versus Tidway, you stopped doing something. The example would be Feinberg versus Pfeiffer, you quit your job, or retired. So the second element is actual reliance upon promise. So if the promise would reasonably induce action and forbearance, but you don't in fact act or forbear, then there's no promissory estoppel. So the first element is essentially, would it reasonably cause you to do what you do? The second element is you rely upon the promise. The third element is justice can only be served by enforcement. It would be unjust to force the promise. So three elements: reasonableness, reliance, and injustice. There are options, not really for you to know yet, but keep in mind that there's some agreements which don't even need the reliance element, such as charitable marriage. Let's see. So promissory can even apply, and here we think about the subject of pre-contractual liability, when there is no contract and therefore no breach. Promissory estoppel does not apply when the reliance is not reasonable. So those are the general rules for promissory estoppel. And we are always looking for some element of reliance, though the damages awarded under promissory estoppel may conceivably fall under basis, meaning expectation or reliance or restitution. Generally, if you see expectation damages under a promissory estoppel case, it's because it's substituting in for consideration. Otherwise, you're generally looking for occasional restitution. Some cases helpful to review and looking at models of promissory estoppel. Versus Pfeiffer, as already mentioned. I also mentioned Hoffman versus Red Owl. It's a good idea to just take a look again at Drennan R. Haven. Should you want to look at the restatement that deals with this subject area, I would recommend the second restatement of contracts, section 90. Okay, promissory estoppel basically can substitute in for missing elements of contracts. You want to remember that the basic concept of promissory estoppel, a way to think about it is that you are stopped on the basis of a particular promise from successfully arguing no contract was formed because of an otherwise required element of the contract is missing. So promissory estoppel can kick in to substitute for consideration, to substitute for offer acceptance, or at least a completed offer, as just read out. There still has to be a promise present, obviously, but it doesn't have to meet the legal definitions of offer. The acceptance doesn't have to be finished. That's part of why estoppel can be very useful for contractual liability. And promissory estoppel can substitute for a missing element of a contract, but can also apply when there is financial interest to reliance, even when a contract really has not been. So again, look at your reading material on pre-contract. And you can also think again about Hoffman versus Red example. Okay. No new notes about sound quality. I assume we're doing right there. Let's talk a little bit about remedies. I'll say a little, I'm going to have to push forward time-wise. I'll say a little about remedies, a little about mistake, and then we'll move forward into any of your questions or comments. So again, you should at this point know the three damage interests well. These include expectation, reliance, and risk. Expectation, in essence, is just what has been promised that you expected to receive. You don't have to have been harmed, general disappointment, nor does the other party have to be unjustly enriched. It is simply what you expect based on the promise. If a contract was formed, expectations, damages may apply. Even if a contract would not normally be formed, promissory estoppel might still substitute for consideration, for instance. Expectation damages. Reliance damages put the promisee back where no contract had existed. So this is about remedying harm to the promisee or to the offeree in whatever case it applies. So if the promisee relied on the existence of as a result, suffered a harmed in such way, talking about inconvenience as discussed in White versus Benkowski, or incurring expenses, or contributing something material, right? The other party benefited from it. Reliance damages recoup that loss. Reliance consequences tend to be less generous than expectation damages. Remember, damages are about what you promised. Reliance only gives you back what you have actually lost. And we can think about our initial case model where we were looking at the dispute over the token, which gives us a good sense of the difference between reliance damages and, let's say, either expectation damage outside the bounds of contract law, such as disgorgement of all profits, punitive damages, or area like copyright damages, pretty typical. Restitution is about undoing unjust enrichment. So whereas reliance and expectation look at what the promisee expected or what harm the promisee suffered, restitution is about putting the promisor back into the position it was in prior to the contract. If they got some unfair, it has to be returned to the promisee. Remember that this need not be money. It might be payback for labor. So restitution is usually, not always, the least generous of the three forms of damages. But again, it depends on the particular context and facts of the case. Let's see, expectation damages, some good cases to look at. Certainly you can take a look at Hawkins versus McGee. It's also a good place, again, as noted, to review the theory of efficient breach and related concepts. And again, we want to remember, though I would never say there are no exceptions in contract law because there are some, the general rule is punitive damages do not apply. crucial to highlight about damage interest at this point. So what if you're not getting damages, right? We did talk about quantum merit a little bit, which again you want to keep in mind a mechanism, and that is damages, before damages. Quantum merit, right, can apply when the exact terms of the contract do not specify what damage, but the court is clear that you do deserve them. And so what you're arguing is basically what is customary or normative, what is a reasonable standard for that particular form of work or contribution. The industry norm, for instance, is one of the factors we look at in evaluating quantum merit. Again, it is a tool for determining how much money you should get when it's been established that you are entitled to damages. Specific performance, equitable remedy. So generally, the rule is, and you can think about some of our recent discussions, specific performance is not usually supported by courts. When it's available, it's because a legal remedy is impossible, if it's too small, or if you've got a really information, determine, as we discussed recently, what the right economic remedy would be. When the contract terms are particularly indefinite, specific performance is generally not available. Let's see. So specific performance, again, implies not just as a general discretionary mechanism for the court, it kicks in when the available monetary remedies are not going to work for some reason, cannot be determined, are not fair. Okay, I think that's everything I want to hit about remedy. Last, I just want to say a few things. Mistake. So I want to encourage you to review some of the cases which issue of mistake, including which is called Elsinore. Pay some attention to for rescission of a mistake, which I believe you can locate in Elsinore. So for instance, the 4 elements for rescinding a mistake of fact, particularly in the issue of like a mistaken bid, include: is the mistake material contract? Right, so it has to be. Is it not the result of the neglect of a legal duty? So if it was the result of a legal duty, then you cannot rescind a mistake of fact. Would enforcement be unconscionable? You can rescind a mistake of fact if enforcing the mistake would be or unjust. And the other party can basically be placed back quo. In other words, the other party did not rely, did not suffer a detriment based on relying on your mistake. So no reliance to the other party. The term that's in question for mistake of fact is material to the contract. You didn't make the mistake by neglecting something that you were legally obligated to do, and enforcing the mistake would be unjust. The 4 elements we look at for rescission of a mistake. Okay. We also want to that in general, we do not assume that making a mistake and considering factors relative to a contract are going to be a defense for breach. That Eastern Airlines versus Gulf Oil on that point. Okay. I think before I open this up to Q&A, I'll just say a few more things about basically encouraging you to look closely at pre-contractual liability. So our general material on options contract is covered on page 171 and continuing through Dickinson v. Dodd. And I encourage you to look at Cali Lesson 9B if you want more clarity about options contracts. You also want to keep in mind that there's some relevant discussion of the application of options contracts under pre-contractual liability. So we want to remember that when there is basically an option contract for the purposes of pre-liability, it exists as discussed around, I believe it's page 220, the when one party has invited performance based on a promise, we expect the other party to perform and performance begins. That's our Brooklyn Bridge hypothetical. So if you are partially performing and you invited performance for and the other party invited for a promise, and in general we say that's enough to indicate an option contract exists for the purpose of contractual liability, provided other elements or estoppel can be argued. There still has to be some basis to enforce liability without the full existence of a contract. Generally, we look there to reliance or restitution interest because it's hard to argue expectation, though I wouldn't say you never could. You don't have a fully formed contract. Okay, I think that's everything that I'd like to highlight in preparation. Malone, which part did you want me to repeat? Go ahead and type it. I didn't see your note till now, so I'm not sure which case I was talking about. Mistake. So Eastern Airlines versus Gulf Oil is a good example of when mistake was not a good defense for breach. Elsinore lays out terms for when you might rescind a mistake of fact. Those were the two cases I discussed relative to mistake. There are a few others that we've talked about that are somewhat relevant. But those are the two I would highlight for now. Okay, so I'm opening it up to general Q&A for the next 20 minutes or so. And AJ, go ahead and remind me what it was that you were asking earlier.